So the next topic I wanted to jump into is notices to employees. And the first item I want to discuss on this is the Workplace Know Your Rights Act. This has been in the news a lot. Our clients have been talking a lot about this as well. So the effective date on this, it requires employers' compliance by February 1st, 2026. And the purpose behind SB 294 is that it creates a new labor code section aimed at ensuring that workers understand key employment and constitutional rights. So it introduces new annual notice, training, and record keeping requirements for employers, and as well as employee protection and enforcement provisions. So um, the employer notice requirements requires an annual written notice. So by February 1st, I'll go to the next slide here. Employers, so February 1st, 2026, this is when the first requirement kicks in. And then every year thereafter, employers are going to have to start providing a standalone written notice to all current employees using any normal communication methods like email, text, personal delivery, and then new hires upon hire, and also each employee's authorized representative, such as a union rep, if any. So the content of the notice, the written notice must include an explanation of the workers' compensation rights and the Division of Workers' Compensation contact information, notice requirements for immigration agency inspections. This is under Labor Code Section 90.2, protections against unfair immigration related practices, the right to organize, form, join union, or engage in concerted activities, and then constitutional rights during law enforcement interactions at the workplace, such as Fourth Amendment search and seizure, Fifth Amendment due process, and self-incrimination. So these notices also have to include new legal developments that are going, and you ask, what are these new legal developments that we're going to have to put into these notices? The Labor Commissioner is going to set out those that need to be provided in these notices. And then also have the list of enforcement agencies that oversee these rights. So there is a language requirement. The notices have to be provided in the language normally used with the employee if available on the Labor Commissioner's website. And they will be publishing these by January 1st, 2026. So keep an eye out for that. Employers have to keep proof of the notice delivery for 3 years. And the Labor Commissioner will be publishing that template that I mentioned by January 1st. They will be also creating 2 educational videos by July 1st, 2026. One will be for employees on their rights, and there will be another video for employers on compliance and constitutional rights. So keep an eye out for that by July 1st of 2026. Um, and then by March 30th, 2026, there is also a requirement that employers must allow each employee to designate an emergency contact who should be notified if the employee is arrested or detained. So there's some additional requirements there. I'm not going to cover all of the enforcement and anti-retaliation provisions. There's a lot here, but just to keep moving along, the key dates I've got set out on this slide. And if you have any additional questions, there's a lot there. We've got some articles posted on the blog as well, our blog, that go into these details. So with that, I wanted to quickly review SB 617 about Cal Warn. It does not, this new law does not change the standard for Cal Warn, who it applies to, and when the warning notices have to be provided to employees for plant closures, layoffs, or relocations. But it does require new disclosures, very detailed disclosures in specific language that needs to be provided to employees that are affected by these plant closures, layoffs, or relocations. So I'm not going to go over it today, just in interest of time. We do have an article on this as well on the blog if you want to look at that. But it's very specific now on what the notices and disclosures and information that needs to be provided to the employees for warn notices.